Start. The petitioner herein filed an ejectment suit in the City Civil Court, Calcutta against the predecessor of the present opposite party's rent in respect of the suit premises was being deposited in the City Civil Court in compliance with the provisions by the West Bengal Premises Tenancy Act 1956. Subsequently, the said ejectment suit was transferred to the Small Causes Court at Calcutta when the West Bengal Premises Tenancy Act 1996 came into operation. The defendant tenant, in spite of the knowledge of the same, continued to deposit rent of the suit premises in the City Civil Court. The petitioner plaintiff then filed an application under Section 17(3) of the West Bengal Premises Tenancy Act 1956 for striking out the defense of the defendant against delivery of possession of the suit premises. After the case was transferred to the Small Causes Court at Calcutta, the defendant appeared there and filed an application under Section 17(1) of the said Act for an order to deposit rent in the Small Causes Court at Calcutta. In the meantime, the original defendant expired and therefore their successors were substituted. They filed an application under Section 151 of Civil Procedure Code with a prayer for an order from the Learned Trial Court that their deposit of rent in City Civil Court be treated as valid deposit. The Learned Trial Court allowed the said prayer of the defendants. The plaintiffs petitioners have now come up with the present revisional application against the said order before the Honorable High Court. Para. Point for consideration is whether the deposit of rent in the City Civil Court was a valid deposit. Para. Held, the defendant tenant has now only two options, that is, either to pay the landlord directly or to the court concerned. In this instant case, the tenant had deposited the rent before the City Civil Court where the suit was initially filed and had deposited then rent up to 2004. This goes to show his bona fide in paying the rent. It is true that technically it is an invalid deposit but not a default in real sense, and it may be termed as an irregular deposit and not at all a case of non-deposit of rent. Para. Revisional application is dismissed. Para. The judgment of the court was as follows. Para. Challenge in this revisional application is to the orders number 149 dated February 23, 2017, order number 155 dated July 20, 2017 and order number 157 dated August 7, 2017, passed by the learned judge, second bench, Small Causes Court, in connection with ejectment suit number 258 of 2001. Para. The present petitioners are the plaintiffs of that ejectment suit number 55 of 1995. He has filed the suit against the defendant opposite party on the ground of reasonable requirement and default in payment of rent since April 1989. According to the petitioners, initially one Ghanshyam Das Agarwal was a monthly tenant under and one Anchan Behan Saad, since deceased, in respect of 3 rooms on the first floor of premises number 9, Chor Bagan Lane, P.S. Jorasankho, Calcutta, 7,07,000 at rental of rupees 205, payable according to English calendar month. The second said Achal Ben Saad died, leaving a registered will and by which he bequeathed his properties to the petitioners. In the year 1991, he obtained a letter of administration in respect of the said will and took charge of all the properties in terms of the said will. he used to collect rent from the tenant of the suit premises by granting rent receipts. On 7th July 1994, he had sent a notice to quit to the predecessor. Stop.